Thank you all so much for coming. We are going to have an excellent event today. We're very excited to talk about the constitutionality of President Trump's travel ban in what is now the third iteration of the ban. It's evolved a lot, as you'll hear today, and we're excited to learn from it. This is a big day for us as well. Yesterday we elected my successor. I will obviously be graduating, won't be here next year, and I'll be replaced by Matthew Bell here. So we're really and at this time I'll turn the time over to him for the pledge and to introduce Josh Blackman.
All right, thank you so much for joining us today, for coming in large numbers. We're very grateful to have Josh Blackman, which if you have a chance, you should follow him on Twitter.
Josh M. Blackman.
And so today, Professor Blackman is coming all the way from the Professor of Law at South Texas College of Law in Houston, which is a place I love. We're very grateful to have him today. We are co-hosting an event with the Immigration Law Club. And I'd like here to introduce Professor Blackman first. Professor Blackman specializes in constitutional law in the United States Supreme Court and the intersection of law and technology. Josh is the author of a critically acclaimed, unprecedented constitutionality challenge to Obamacare. He was named by Forbes magazine as 30 under 30. Prior to being a professor at out in South Texas in Houston, Professor Blackman clerked for the Honorable Danny Boggs on the U.S. Court of Appeals for the Sixth Circuit, and for the Honorable Kim Gibson for the U.S. District Court of the Western District of Pennsylvania. Josh graduated from George Mason University School of Law, which I believe since then has been named Scalia School of Law. And so we're very grateful to be here, and I'd like to join me in welcoming Professor Blackman. Thank you.
We're also really grateful to have Brittany Nice shown here today. She joined the ACLU of Utah as Executive Director in August of 2016. Before that, she was in Washington, D.C., working as the Director of Advocacy at Lutheran Immigration and Refugee Services, where she advocated on behalf of refugees and unaccompanied children, immigrants in detention, and other vulnerable populations. Prior to that, she was the Director of Policy and Legal Affairs at the National Immigration Forum, where her advocacy focused on due process concerns and overdue reforms of the immigration system. Prior to that, she also represented detained individuals facing deportation and advocated for humane detention conditions as the legal director at the Capital Area Immigrants' Rights Coalition. She also spent some years in private practice as well as part of the litigation team at Frank Harris, Shriver, and Jacobson in D.C. She's also been recognized as a national expert and has testified before the U.S. House of Representatives and the Inter-American Commission on Human Rights. She was born on Hill Air Force Base here in Utah and graduated in Ogden from high school. And she holds degrees from the University of Notre Dame and the Northwestern University School of Law, and is admitted to the bar in D.C. and Illinois. And she's happy to be back in Utah with her family to enjoy the outdoors. So welcome, Brittany.
Thank you all so much. As you can tell, my voice is not the best today, but you will get the best shit you have. Also, my first time in Utah. Thank you so much to BYU for hosting me. Today we're talking about the travel ban. And before I get to the travel ban, I want to talk about another case which you probably studied in constitutional law, called Texas v. Johnson. I feel much about the travel ban as I do about the Texas v. Johnson case. This case considered whether a person can be arrested for burning an American flag at a political protest. The decision broke down on a 5-4 line, but to the surprise of many, Justice Scalia cast the deciding vote in favor of the flag burner. Now, Scalia was no fan of flag burners. He once said, quote, "If it were up to me, I would put in jail every sandal-wearing, scruffy-bearded weirdo who burns the American flag." Scalia said, "But I am not king." Indeed, Scalia felt the answer was compelled by the First Amendment, even though he disagreed with the result. Texas v. Johnson is a good gut check for lawyers. If your understanding of constitutional law overlaps entirely with your own philosophical beliefs, you may want to reassess the former. That is much how I feel about the travel ban. I'm a libertarian, and I generally favor open immigration policies. I think the idea of banning the entry of aliens from certain nations merely because those countries have been associated with terrorism is an awful policy. These executive orders will cause hardship to families, refugees, and those seeking a better life. I am also doubtful that this policy will do much to improve our national security. Yet, with my cards on the table, I am firmly convinced that Congress gave the President the power to take these actions, and the Constitution does not bar him from exercising the powers in the manner in which he did. So my talk today will be in 5 parts. I can make it more fun. First, I will walk you through the history of the travel ban, including statements by then candidate Trump. By the way, good job, Utah property. Including statements by then candidate Trump made, as well as statements made by now President Trump about that ban. Second, I will discuss the contents of the 3 executive orders, which have each been halted by the courts. Third, I will discuss whether Congress has afforded the President authority to take these actions from a separation of powers perspective. Fourth, I will discuss whether these actions conflict with the First Amendment, namely the Establishment Clause. Finally, I will give you a preview of the Supreme Court's arguments in what will be Hawaii versus Trump in April. So our story begins before the election in December 2015. Then candidate Trump called for, quote, total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what is going on. Over the next few months, Trump would shift his position from a Muslim ban and now call for extreme vetting of people seeking entry to the United States from certain territories. Or did he change his position? Cue PolitiFact, right? During a July 2016 interview on 60 Minutes at CBS, Trump told Leslie Stahl that she can still call it whatever she wants, but we'll call it territories, okay? Was that an act of repudiation or a wink and a nod to the alt-right? A week later on Meet the Press, Trump seemed to clearly repudiate the old policy to Chuck Todd. I'm talking territory instead of Muslim. Did he really mean it, or was it just fake news? Alas, the burden of reconciling these statements has shifted from fact checkers to federal courts. At least one judge in Virginia found that Trump's CBS interview connected his initial call for a Muslim ban with the ultimate order in January 2017. This is the missing link. By way of background, it has come to this. Called upon to decide whether the president's immigration policy was designed to exclude Muslims, the federal courts have confronted a bizarre question. Is Leslie Stahl or Chuck Todd a better interviewer? These, I'll submit, are not questions for the court. So let's start with version 1.0. President Trump's first executive order was signed on Friday, January 27, 2017, just about a year ago. It sent shockwaves through our legal order. For 90 days, aliens from Iraq, Iran, Libya, Somalia, Sudan, Syria, and Yemen, 7 countries, were deemed detrimental to American interests, will be denied entry to the United States. And the refugee program will be suspended for 120 days. Syrian refugees, in particular, will be denied entry indefinitely. Almost immediately after the order was signed, airport officials began to detain nationals of these 7 nations. I asked Brittany, was anyone detained at Salt Lake City Airport? They're working on it, not quite sure yet. Soon, judges in New York, Virginia, Washington, and elsewhere order their release by granting writs of habeas corpus. But these emergency proceedings were the beginning of the lawfare. Eventually, a federal judge in Seattle issued what amounted to a global injunction barring the enforcement of the first executive order. The Ninth Circuit affirmed that, and en banc review was denied. The Trump administration did not appeal that to the U.S. Supreme Court. Instead, they withdrew the order and said we'll start over again. On March 6, 2017, Trump issued the second order called 2.0 that superseded the first one. So there were some changes. First, Iraq was removed from the list, and also green card holders, lawful permanent residents, were not subject to the ban. Now, rather than quantifying whether aliens from these countries engaged in terrorist acts, which was always the wrong question, new findings instead established the U.S. lacked sufficient diplomatic relations with these 6 nations to trust their screening mechanisms. Okay? This second order was only meant to be temporary. It would last for 60 days. Once again, federal courts issued global injunctions barring the second executive order. Judges in Hawaii and Maryland were leading the pack. Those judgments were affirmed by the Ninth and Fourth Circuits, and then it went to the Supreme Court on what's called a motion for a stay. And in a decision that surprised many, not me, the Supreme Court allowed much of version 2.0 to go into effect. Not all of it, but they allowed it to go into certain effect to aliens who lack what's called a bona fide or an adequate relation to the U.S. person. This was the first sign that perhaps local courts were not quite getting it right. But again, version 2.0 was only designed to last for 60 days. And after 60 days, it expired. And now we have travel ban 3.0. It's actually not an executive order. It's called a proclamation. There's not much of a difference. I'll just call it 3.0 to make it easier. For the new proclamation, the Department of Homeland Security created a baseline for each nation to meet that said, is this country meeting their security baseline? Originally, 16 countries were found to be deficient, with others at risk. After further review by the U.S. government, it determined that 8 countries were deficient in how they share information with the American government. These 8 countries were Chad, Iran, Libya, North Korea, Syria, Venezuela, Yemen. Okay. Now, North Korea and Venezuela don't send many immigrants to the United States in this context. North Korea sends virtually none. With respect to Venezuela, it only applied to certain diplomatic officials. So these 2 countries didn't make much of a difference. But you're still left with a number of predominantly Muslim nations whose citizens were subject to this ban. Once again, the usual suspects challenged version 3.0 in court, and federal judges, once again, in Maryland and Hawaii, issued global injunctions barring the executive order, sensing a pattern, right? A lot of the stuff became almost automatic. You knew what was going to happen. It wasn't much of a surprise. In fact, a lot of the briefs started having a lot of copy and paste because it's the same issue with a few tweaks. Now, this issue is before the U.S. Supreme Court. The Supreme Court will hear arguments on version 3.0 in April, actually April 25th. You can see that day at the Supreme Court. So now, that background out of the way, the long background, I'd like to talk about the various grounds on which I think President Trump is acting within his statutory and constitutional authority. So the first relevant statute that you need to study is one enacted in the 1950s. 8 U.S.C. 1182F. I'll read it to you. It says, whenever the President finds that the entry of any aliens or of any class of aliens into the United States would be detrimental to the interests of the United States, he made a proclamation, and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens. This is a very broad delegation of authority. Now, This does not concern whether the president must give visas or any sort of domestic matters. This concerns the act of entry. And if you're not an immigration scholar, which I'm actually not, I pretend to be, under immigration law, entry is a very specific act. When you show up at Salt Lake City Airport and you're an immigrant, you don't enter the United States till you clear customs, right? Even though you're on U.S. soil, you are not yet in the United States, which is why people held up at airports filed what are called habeas corpus writs, right? They weren't subject to the same sorts of laws that you would have if you were inside the interior. This statute operates to give the president the power to deny entry to those he deems detrimental. Now, this is a very broad delegation of power. It doesn't give the president much guidance. It just says detrimental to the interests of the United States. One judge in the Fourth Circuit actually said this statute might violate the non-delegation doctrine. Remember that from common law? Remember Schechter-Poultry, right? That the Congress can't give such unbounded discretion to the executive. Now, that would usually be music to this anti-administrative ears, right? Bring back Schechter-Poultry. Alas, it's misguided. The president here is acting not only with his statutory authority, but also his own inherent constitutional authority. And the Supreme Court explained in the case from the 1950s that the president has an inherent power to exclude aliens by virtue of Article 2. Right? Even if Congress had never enacted the statute, I think Trump would still win. He doesn't need it. Right? He has a statute, and he has his own constitutional authority. And Justice Jackson, in the Youngstown case, teaches us that when the president acts with his own statutory authority, plus constitutional authority from Article 2, judicial review is at its minimum. This is the first year of Justice Jackson's opinion, Youngstown Sheet Tube Company versus Sawyer. Very important decision. So on this front, the president, I submit, has the statutory power. Oh, this is good. Close to my mouth. The statutory power. Oh, this is much better. The statutory power to exclude evidence. Oh, this is perfect. I'll punch over. Okay. So that's the first statute. But there's another statute that's relevant. This is a statute passed in the 1960s as part of the Big Immigration and Nationality Act. And what this statute says is that no person shall receive any preference or priority or be discriminated against in the issuance of an immigrant visa because of the person's race, sex, place of birth, nationality, or residence. Okay? This was designed to kill the quota system. Prior to the INA, the Immigration and Nationality Act, people from certain countries were just disfavored of how many visas would be issued. It's straight up discrimination. There's no nice middle label. This statute killed it. So the argument is, aha, the traffic ban violates this statute. I think that argument is problematic for a couple of reasons, right? First, this statute concerns immigrant visas, not entry. This statute doesn't put any limits on who can enter, just issuance of visas. Second, it only concerns immigrant visas, not non-immigrant visas. So, for example, tourist visas. The president can ban them notwithstanding the statute. So even if this statute did control it, only affects a small number of people who are actually entering the United States. But even there, I don't think it works. Because I read through section paragraph A. The next paragraph B says, nothing in this paragraph shall be construed to limit the authority of the Secretary of State to determine the procedures for the processing of immigrant visa applications or the location where such applications will be processed. This is a key word, procedures. I think in light of the constitutional issues at play, the best way of reading this statute is that there are procedures that can be implemented, and those procedures can take consideration nationality of the applicants. Reading the statute this way might not be the ideal way, but it's a permissible way to read it to avoid very stark limitations on the president's power. I'll give you an example. Let's say we went to war with Germany, it's happened before, and the president said, I'm not issuing any immigrant visas to German nationals. Would you really think that this statute could bar the president from doing that for a minute? Would we need to repeal the statute where the president's giving visas to German nationals? You can't read the statute that way, it's insane. So I think you read for procedures, the way I recommend Heralding Scotia, right, in Salt Lake City. So that's the statutory argument. The second ground is constitutional, and I'll mention this a little bit briefly. The Establishment Clause of the First Amendment has been interpreted to say that Congress can't put any preference for religion or non-religion, right? It doesn't just limit to establishing a church. That's not what the court has read, right or wrong, the court hasn't read it that way. But it applies where the court can establish a preference on religion or another. The argument is that by singling out predominantly Muslim nations, the travel ban expresses a disfavor of Islam and maybe even a preference for Christianity. Okay? There is a threshold question which none of the courts of appeals have even bothered to entertain. Does the Establishment Clause even apply in immigration context? I wrote about this over a year ago. I have debated this a dozen times. No one, not once, has provided a response to this front. It may happen today. In our immigration law, religion is a very big deal. I'll give you a couple examples. Under our immigration laws, if you are a minister, you can apply for a special visa that no one else can apply for. We have special preferences. We expressly favor ministers. Now, what is a minister? If you look at the regs, it's defined as someone like a brother, sister, monk, or nun with a lifelong commitment to religion. That is expressly considering Catholic structure. We have a statute on the books for decades, implemented by regulations which are around for decades, that preference people of the cloth who follow the Catholic faith. If that were a domestic statute, it would survive 5 minutes. But there's never been even the slightest suggestion that this provision is unconstitutional. Another one. In the 1980s, something called the Lavenberg Amendment that was enacted. The Lavenberg Amendment. It gave preference to refugees in the Soviet Union who were, quote, Jews or evangelical Christians. The statute on its face said Jews or evangelical Christians who were in the Soviet Union. If a domestic statute had that language, it would be easily sued in 5 seconds, right? As they probably would win too. I think they get the fees on that case as well. In the context of asylum, to determine credible threat of prosecution, courts must look at doctrine. How does someone believe in this faith? What are the contours of this faith? Again, these are questions that simply would not be allowed in domestic context. So, look, maybe I'm wrong, right? Maybe the Supreme Court will say that we're going to apply all domestic establishment clause case law to the context of foreign policy and immigration. I don't think they will. They'll create an entire disaster with the immigration courts, right? If now all these various visa categories are subject to challenge, it would really mess things up. I think the better answer is that in the context of foreign policy, you don't apply establishment clause scrutiny. You apply a rational basis review. And this is what the Solicitor General's argued. The executive was reviewed for mere rationality, and there's more than enough of a rational basis to justify this law. This also allows the court to talk this thorny issue. Can courts read the president's tweets? Now, lower court judges have loved citing the president's Twitter. Often they just enjoy it. Tweet, 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 right? Let me make you a prediction. The majority opinion, whatever it says in this case, for Trump or against, will not mention Twitter. We'll put some bank on that. That will not inform the president's opinion. Right? So, I've got 4 minutes left. The vote's about to go, so let me wrap up with what I think will happen at the oral arguments. When a lower court is deciding an issue of this magnitude, no one really cares, right? I don't think no one cares. What they write matters is the opinion of the courts. But in 20 years, when you're reading about this case in your common law casebook, no one's going to remember what Chief Judge Gregory said about this, right? No one's going to remember what Judge Richard Paez said about this. No one's going to care. They'll care what the Supreme Court said about this. And this matters. The Supreme Court's decisions are cited for decades to come in contexts that we can't imagine, right? When the Supreme Court considered the case of the Nazi saboteurs, they didn't know what Al-Qaeda was. They couldn't imagine Guantanamo Bay, but that decision affected how President George W. Bush would keep people in Guantanamo Bay. When the Supreme Court's deciding this travel ban, they're not only deciding for President Trump, they're deciding for President Elizabeth Warren, right? Malia Obama, right? Whoever it happens to be in the future. These decisions are important. And the sorts of decisions the lower courts have not afforded the president the sort of deference he's due in these cases. Again, I think these policies are awful. These policies are not good. But if indeed courts can scrutinize the president's actions in the manner in which they've done, there's not much President Trump can do. I'll give you a very easy example. President Trump has made comments offending every single group of people in the United States. Men, women, blacks, whites, Hispanics, everyone, Asian, right? Gays, lesbians, everyone. He's offended everybody. You know that, right? If indeed it's the case that President Trump's actions disables him from acting in this context, right? If that indeed is the rule, he cannot be president. Indeed, one court has already held that because of President Trump's animus towards Mexicans, build a wall, right? He can't rescind the deferred action policy. That cannot be the rule of law. So I expect what the Supreme Court will do here is they will dial back, lower the temperature of how courts are treating President Trump. He'll be for at least 3 years, probably 7 more. And I don't think after this case, the courts will consider to rule in this fashion. Thank you so much. I'm going to have a cough drop. And let my good friend please see you for the provider. Thank you so much. Sorry.
Well, I do agree with Professor Blackman on the fact that this is a terrible policy. He's also given me a lot to talk about in my 20 minutes. So I'm going to spend just a couple saying I really take issue with the title of this presentation, When Judges Revolt. The court's ability to review an executive order or a law goes back to Marbury v. Madison. So I don't think we have an instance of activist judges or revolting judges here. We have a separation of powers issue playing out in the courts where we have judicial thinkers interpreting the Constitution and analyzing whether what the president did falls within his statutory authority or the limits of the Constitution. And as also was mentioned earlier, every single court that has reviewed this has found grave problems with what President Trump has issued. Professor Blackman also started with reference to some constitutional bedrock cases. He chose a flag burning case. I'm going to choose Korematsu, which is a case that is a stain on America's history. And in that case, as we know, people of Japanese descent, including U.S. citizens, were held in internment camps. This is an issue very near and dear to Utahns, since we were the host of at least one of these internment camps. That action was permitted by a Supreme Court giving overly broad deference to a president's ability to act in the nation's security. That's a national security case, which is now widely regarded as a mistake. That's an instance of the court not checking a president's authority, not finding there were constitutional rights held by those U.S. citizens and the other Japanese who were interned. So let's move on to what we're talking about today. Let me go back just a bit and set the stage, fill in some of the gaps. The history of this issue is it's almost impossible to keep up with. It does seem to change every month. Some big new opinion is issued or the Supreme Court makes some announcement. But in that first iteration of what I call the Muslim ban, refugee claims were prioritized for applicants belonging to a religion that is a minority in their country of origin. That has widely been interpreted as favoring Christians in a Muslim majority country. And courts have found that that is an example of a violation of the Establishment Clause buried in the very beginnings of Trump's executive order. Let me also mention a few of the things that President Trump has said about his intent. It hasn't all been on Twitter. We know he's prolific on Twitter, but he did also ask Rudy Giuliani for help in establishing a ban that would keep Muslims out in a legal way. So there are some very blatant comments made by President Trump laying bare what he was trying to do here. He has, on his speaking tours, so after the election, he's continued to have these campaign rallies. He has said over and over again that he doesn't want the watered down version of the Muslim ban that we have now. He wants his original version, and he's not happy that the political correctness has watered down his travel ban. Stephen Miller has also made statements that there haven't been any real changes to the Muslim ban. There's just been minor technical changes, kind of underscoring what the court has found, which is that the fatal flaw of the original executive order has continued through version 2 and the proclamation or version 3. We don't know the answer that was asked as to how many people were detained at the Salt Lake International Airport because the Department of Homeland Security won't tell us. From the beginning, the implementation of this ban was a nightmare. The first iteration took effect immediately. We are still trying to learn what instructions immigration agents were given when it went into effect while some flights were in the air. So individuals landed, they had a valid visa when they took off. When they got to the airport, suddenly this executive order had issued and they were turned around and deported or attempted to be deported. So that's why we don't know if there are any individuals detained in the Salt Lake International Airport. They won't tell us. Hopefully we'll find out soon. I'm not going to try to read into what the Supreme Court is going to do on the last day of the term. I think that's difficult to know, primarily because even though the Supreme Court has made two kind of statements about this case, they have given no hint as to what they think about the merits. Their orders have been, let's stay what the lower courts have done until litigation has ended and it has had a chance to work its way all the way through the system. The orders have been, I think like one sentence or two sentences. So nothing that I think really reveals how the justices will rule on this decision. I agree that history doesn't often quote a district court or circuit court opinion. You always look to what the Supreme Court has found. But it is unusual to have a case that has sparked so much litigation, that has worked its way up through simultaneous district courts, the Ninth Circuit, the Fourth Circuit, and all of the opinions have found the same flaws in legality and constitutionality. I also want to point out that although the Ninth Circuit has the reputation, you can debate whether it's earned or not, of being a very liberal circuit, the Fourth Circuit most definitely does not have that definition. So we don't have a circuit split here. We have two very different circuits coming to more or less the same conclusion. I'm also going to leave a little bit of time to rebut what was said about some of the distinction between immigration and religion. I was an immigration attorney for a number of years. I worked on immigration policy exclusively from 2008 to 2016. So I have some familiarity with those provisions that were mentioned, but I definitely want to get to what the lower courts have found about the president's delegation of authority and the Establishment Clause. So the Ninth Circuit really dug into this section of the Immigration and Nationality Act that does give the president authority to suspend entry of any class of aliens for such period as he shall deem necessary. I agree that when you first read that, you're like, whoa, that is a really broad delegation of authority. What the Ninth Circuit found in their most recent opinion in December was that we need to pay attention to some of the terminology in the statute. As anyone who's analyzed legislative language knows, the choice of words can sometimes make or break how a court interprets that statute. Here, the Ninth Circuit really focused on the use of the word suspend and for such period, finding that a reasonable person would read that as a limitation, that suspension doesn't mean an indefinite end, and for such period also is seen as temporally bound, not indefinite. And the most recent version of the Muslim ban did impose an indefinite suspension on some of these visa issuances. They also really latch onto this word presidential finding and go into great depth as to what the president shall do when he's making a finding that allowing entry is detrimental to the interests of the United States. So what the Ninth Circuit found is that the president's executive order deviates from the statute, from the legislative history, and from presidential practice. They talk about this at length. They say that the Constitution gives Congress primary, if not exclusive, immigration authority. So if anyone remembers when Arizona decided to pass this papers, please law, and they were essentially turning Arizona police officers into immigration police, the U.S. Supreme Court said, no, this is a federal issue. Only Congress can decide issues of immigration policy. Here, they found that Congress did delegate some authority to the executive branch through the Immigration and Nationality Act, but it's within limits. There's also many provisions in the Immigration and Nationality Act that allow for individuals to be banned, to be considered inadmissible for reasons of terrorism, suspicion, if they're considered a public safety threat. So the Ninth Circuit found that the president doesn't need to categorically bar nationalities. He can do so on an individual basis. When someone shows up at a U.S. consulate asking for a visa, there are grounds to bar those people if there's a national security risk. So the big thing that the Ninth Circuit orders here is that there's a separation of power concern because, quote, the executive cannot, without assent of Congress, supplant its statutory scheme with one stroke of a presidential pen. They also find that a sufficient finding is required and that mere nationality isn't enough to say, you're from Chad, you're dangerous, you can't come in. There really needs to be more of a connecting of the dots. You're from Chad, your brother is the president of the local terrorist organization, you definitely cannot come in. That would be sufficient, but just taking a whole nationality and saying, we don't think you are going to be in the interest of the U.S. to admit you, that is overreach of the president's authority. They also say that the proclamation, this is just considering version 3.0, so the proclamation, conflicts with the statutory prohibition on nationality-based discrimination. So to understand what Professor Blackman was saying about the depth of the quota system, that was done around the same time the Civil Rights Act was being passed and the Voting Rights Act were being passed. And I just see no difference in a suspension of entries and other types of nationality discrimination. I think it's really clear here that what the president is trying to do is a blatant violation of the prohibition on nationality-based discrimination. So the Ninth Circuit ends its analysis there. They don't consider the Establishment Clause, but the Fourth Circuit does. And that decision just came out on February 15th. And I think here that this is just the most, from a constitutionally interesting analysis, this is the one that I would recommend you read. They say that this proclamation violates the Establishment Clause by clearly disfavoring Muslims. They do refer to the president's tweets, the fact that he tweeted pretty horrific anti-Muslim videos over the summer. Other comments that he has made about wanting to keep Muslims from entering the United States. They find that this proclamation is unconstitutionally tainted with animus towards Islam. That's a quote from the Fourth Circuit. They find that the government fails to meet its burden on challenge. The government has the burden of showing that the primary purpose of the ban is secular. Despite the revisions that were done, the court finds that it continues to exhibit a primarily religious anti-Muslim objective. They go on to balance the equities. And there is a significant national security interest. I think most courts will take the government seriously if they say we're acting in the interest of the entire United States' security. So the court considers that, but finds that it cannot be in the public interest for the president to violate the Establishment Clause of the First Amendment. They say on a fundamental level, the proclamation second guesses our nation's dedication to religious freedom and tolerance, and when we compromise our values as to some, we shake the foundation for all. They also go on to allow the injunction to go into effect for North Korea and Venezuela, since the animus shown is disfavoring Muslims. Those two countries are not Muslim majorities, so the ban as it affects them does take effect. I should also note, I think you missed this, that on December 4th, the Supreme Court, by saying that they would allow litigation to continue, allowed the Muslim ban to go fully into effect. So it is right now 100% in effect. There was later a specific refugee ban that has also been put on hold by the courts. That again was done, the proffered reason was for national security. There were 11 countries that were barred from sending refugees to the United States, and the program that allows a refugee resettled in the United States to petition for their spouse or children to join them was also blocked by the Trump administration. The courts have not allowed that ruling, that order to stand, and the refugee ban is blocked nationwide. So in just the couple minutes that I have left, I want to talk a little bit about special religious visas and the Lautenberg Amendment. I can't believe I'm having to dig back into my brain to pull up these weird immigration laws, but I did lobby on these for a number of years when I worked for the Lutheran Church's refugee agency. I can tell you that the Lutheran Church, as well as many other faiths, take advantage of the special religious visas that are offered. So it's not only the Catholic Church that uses these, they're ecumenical visas actually. And if you look into our immigration laws, you will be amazed as to the number of weird visas that can be obtained. There's something called I think it's like special ability visa that lets models or professional athletes or someone who is the only researcher in the world working on a certain strain of cancer. They all get special visas to come in because of their extraordinary ability. So pointing to just one category of visa doesn't, to me, show that immigration law should be treated differently from any other statutory scheme that we have. The Lautenberg Amendment that gives special protection to Jews living in the Soviet Union was put into place because of the Refugee Convention. The Refugee Convention was adopted by the U.S. in the 50s and the 60s and requires someone to show that they were persecuted on account of race, religion, political opinion, or membership in a particular social group. Here, so many Jewish people were fleeing the Soviet Union because they were being persecuted that Congress passed a special law basically recognizing them on their face as having a valid refugee claim. So all this did was save the same reports being filed to show that yes, Jews are persecuted in the Soviet Union. It just like congressional recognition that Jews in the Soviet Union are being persecuted. So I don't think that amendment shows that immigration laws should not be subject to the First Amendment of the United States Constitution. So I will leave my remarks at that.
We have only the briefest time time, so I'll respond briefly to the Ninth Circuit decision. The Ninth Circuit decision on the non-delegation doctrine didn't reference a very important case called Shaughnessy versus Knopf, K-N-A-F-F, which held that any equivocation the president has inherent power. If you accept that, the Ninth Circuit's analysis is topless. I'll leave it there because I have like 8 minutes left. I want to get lots of questions. I'll sit back down here and I'll try and serve my way. So, questions, please. Yeah, actually, I'll stand up so I can see.
Yeah, I think I can.
Yeah, so right here, yes, sir.
Is there any broader issue with, you think the Supreme Court will address with, I don't know, judicial supremacy or the ability of, like, district courts being able to grant a worldwide injunction?
Yeah, I'll take it. The question was, will the court address the ability of district courts to issue a global injunction? I used to do another debate last year on a case called U.S. v. Texas, which involves Texas's challenge to President Obama's Deferred Action Program. Nationwide injunctions aren't new, and conservatives used them very effectively during the last years of the Obama administration. I will note they've been used much more frequently in the Trump administration, but they're not novel. I don't think the court likes them very much, because it requires the court to intervene at a very early stage by granting emergency stays, and bringing records to a couple of them already. Usually the idea is the court issues an injunction, limited in scope, goes to the Court of Appeals, creates a circuit split, and gets the Supreme Court a couple years later, maybe. Now it gets the Supreme Court in a few weeks, maybe even a month. So I think the court may address this, but I don't know. Really, you have anything to add? Thank you for the question. Yes, in the back.
So, I just have a question trying to understand this a little bit better. I'm an immigrant, so I just need to clarify that first. Any question tends to be viewed as a challenge to it. How is this being approached? Who can bring a suit for this travel ban if it affects non-citizens of the United States?
Yeah.
Is it family members of potential?
Yeah, that's a good question. Yeah, it's a very good question. Brittany, you want to take that?
Sure. So the way this has played out is there have been a lot of standing analysis in this case as well. And most of the challenges have been brought on behalf of family members who are in the United States. A mother is applying for a visa to come over and meet her new grandchild, say, and the adult child is a U.S. citizen in his petition. So there are a lot of individual plaintiffs.
Yes.
There are also organizational plaintiffs. Some of those are immigrant associations, so like the Center for American Islamic Relations in Washington State, for example, is one of the organizations that has been recognized as having standing. In this case, it's also a little interesting because the state of Hawaii is a plaintiff, and they had to show that their interests would be harmed and if this Muslim ban was allowed to stand. Washington State made similar arguments showing that their economy and their communities benefit from travel and immigration.
Thank you for the question. Other questions? We'll see if anyone else has something back to you for that. Anyone else? All right, go for it.
All right, so a visa, if I remember correctly from the time that I was doing all this, is the right to travel to the United States, right? But the right of entry is determined by the immigration officer.
So let me put it this way. As a general matter, if you have a valid visa and you show up in an airport, that doesn't guarantee your entry.
Of course.
Let's say if you show up to the airport and you Ebola, right? You're not coming in. If you show up and the consular officer asks you a question and it turns out you are not truthful on your visa application, you're not entering the United States. There is a distinction, both in statutory terms and in case law, between entry and visas. And I think this would be a very important part of the Supreme Court's ultimate decision. If Brittany's right, and there's no difference between visa and entry, then Trump probably broke the statute. I do think there's a difference. I think you have to read it that way. Also, in any event, the statute only affects immigrant visas. It doesn't affect non-immigrant visas, like tourist visas, for example.
And the ban affects the entry, not the visa part.
Yes, sir. Other questions?
I want to challenge that a little bit. The way that this ban is being implemented, it's banning the issuance of visas.
Okay, that's what I wanted.
Right, so I had to print this out because it's too complicated to remember. This is version 3.0. These are the different countries affected. There's 8, and they all have different categories of visas that are banned. So for example, if you're from Iran, you can come in on a student visa, but almost nothing else. But if you're from Somalia, you can't get a visa, period.
Unless we have another question as people wrap up, we can save my voice for the rest of the day. Anything else? Okay, thank you all so much.